Yes, appearances, please.
May it please, my lord.
Yes.
I'm J.O.K. Enrique for the claimant.
Yes. Yes. Defense. Mr. Labelewe. What happened to him now? Is it still online?
No, ma. I think his network.
Let me know when it's back, please. Yes, the case is for judgment.
Yes, my lord. As court pleases, the case is for judgment, and we're ready.
Is Mr. Labelewe back?
I don't.
Yes, he's trying his best.
He's coming back. Okay, he's back now.
Okay, thank you. Mr. Labelewe for the defendant.
Stop.
I want to hear him so that I'm sure that we're together. Are you on mute, Mr.?
That's why I can hear. Sometimes that's what we do.
Yes. Is he back?
Yes, my lord.
He's back.
Okay. Yes, Mr. Moshood Alabalewe for the defendant.
Yes. My lord, with your kind permission, I appear with Aisha to Mustafa Al-Kali for the defendant, my lord.
Judgment. The claimant is a former deputy manager of the defendant until his appointment was terminated on the 4th of June 2021. His case, in a nutshell, is that the termination of his appointment was unwarranted as he ought to have been liquidated by the insurers. The claimant contends that on ground of job loss, the loan he obtained from the defendant ought to have been liquidated by the insurers, as same was insured by the defendant. The claimant alleged that his account with the defendant was wrongfully debited after his appointment was terminated, that he is entitled to the refund of the wrongly debited money and also entitled to payment of his terminal benefits. The claimant further alleged that he has suffered irreparable damages by the actions of the defendant. On the premises of this briefly summarized fact, the claimant took out a complaint and statement of facts on the 31st of May 2022, whereby he claimed against the defendant the relief set out as follows. In order not to waste the time of the court further, the reliefs are set out on the face of the judgment. I'll skip it to move on. We have 8 of the reliefs. The defendant joined issues with the claimant in the statement of defense deemed filed on the 8th of February 2023, wherein the defendant denied the substance of the claim. Essentially, the defendant contends that upon cessation of his appointment and as provided in the employee's handbook, the claimant was paid 1 month's basic salary and 2 months' basic salary as ex gratia, and the termination of his appointment was thereby not wrongful. The defendant alleged that the credit facilities of car loan and personal loan obtained by the claimant are still outstanding as at the cessation of his employment with the defendant, but in spite of repeated demands, the claimant has failed, refused, and neglected to pay his indebtedness. Whereof the defendant's counterclaims against the claimant as follows. The counterclaim is as set on the face of the judgment, as skipped in order not to waste the time of the court. The claimant denied the defendant's allegations in his reply to the statement of defense and defense to counterclaim filed on the 16th of February 2023. At the plenary trial, the claimant testified for himself and called no witness. He adopted a statement on oath as his evidence in support of his claim and further tendered a total of 14 documents as exhibits. The claimant was subjected to cross-examination by the defendant's learned counsel, and 8 documents were tendered through him, after which his case was closed. The defendant fielded one Moses Okori as our sole witness. He adopted a statement on oath as his evidence in chief. He was equally cross-examined by the claimant's learned counsel and tendered no documents. Parties filed and exchanged their final addresses in the manner prescribed by the rules of this court. The defendant's final address was deemed filed on the 18th of January 2024 by our learned counsel, Moshood M. Alabelewe Esquel, who formulated 2 issues for determination set forth as follows. 1, whether the claimant has proven his claims and therefore entitled to reliefs sought, I'll take that again, please. The defendant's final address was deemed filed on the 18th of January 2024 by learned counsel Moshood Alabelewe Esquel, who formulated 2 issues for determination set forth as follows. 1, whether the claimant has proven his claims and therefore entitled to the relief sought before this honorable court. And 2, whether the defendant has proven its counterclaim and thereby entitled to judgment. In the final address of the claimant, also deemed filed on the 18th of January 2024, learned counsel J.O.K. Irikefe Esquel adopted the issues formulated by learned defendant's counsel. The defendant did not file a reply on points of law. I have painstakingly examined the totality of the pleadings filed by both parties in contention, the reliefs claimed, the totality of the admissible and relevant evidence adduced at the trial, and the totality of the written addresses and oral submissions of learned gentlemen for 2 parties. And my view is that 3 issues call for determination in the suit without prejudice to the other issues formulated for determination by the respective learned counsel. I shall proceed to determine this issue on the basis of the issues set out as follows. 1, whether the termination of the claimant is wrongful as alleged. 2, upon the resolution of issue 1, whether or not the claimant has established by credible evidence his entitlement to the reliefs claimed in this action against the defendant in the suit. And 3, whether or not the defendant counterclaimant has established by credible evidence to be entitled to the reliefs claimed. In proceeding to determine those issues, I must state that I had carefully considered and taken due benefit of the totality of arguments canvassed by the respective learned counsel in their written final submissions, to which I shall endeavor to make specific reference as I consider needful in the course of this judgment. I should also add that since the focal issue in controversy between the parties and the main and the counterclaim are interwoven, a resolution of the issues formulated will have apparently been determined in both actions at once. Now, as correctly submitted by respective learned counsel, the general principles guiding the proof of a claim for wrongful and or unlawful termination of dismissal or employment have remained sacrosanct. For the claimant to succeed in his claim, he must prove that the defendant breached the condition of service of his employment. See the cases of Amodu versus Amode, Angel Spinning and Dyeing Limited versus Aja, Ogumka versus Corporate Affairs Commission, citation supplied. The testimony of the claimant is that he was employed by the defendant on the 25th of September 2006 as senior banking officer, that the terms and conditions of his employment are contained in the employee's handbook of the defendant, that he rose through the ranks to the position of a deputy manager, and his salary was last reviewed in February 2020, letter of offer of employment, letter of confirmation of employment, employees handbook of the defendant, letter of salary review, pay slips for the months of January 2021, April 2021, and May 2021 were respectively tendered in evidence as Exhibit C1, Exhibit C1A, Exhibit C2, Exhibit C3, Exhibit C4, C4A, C4B, and Exhibit C4C. The claimant further testified that on the 4th of June 2021, Exhibit C5, a letter of termination of appointment with immediate effect on the ground that his services were no longer required, was served on him. The claimant contends that he did not commit any offense or misconduct as contained in the defendant's handbook to warrant the termination of his appointment, that the termination of his appointment without any reason whatsoever is in violation of international best practices, and alleged that having served the defendant since 2006 and due for retirement on attaining the age of 60 in 2030, the termination of his appointment was to deprive him of his full entitlement at retirement. In his further testimony, the claimant tendered Exhibit C6 and C6A, copies of his letters of appeal cataloging his performances in the defendant's employment and sought for his reinstatement, but the defendant refused his request. Letter of defendant's reply to claimant's request for conversion of the termination of his appointment to retirement was tendered in evidence as Exhibit C7. The claimant further alleged that after his appointment was terminated, his account was wrongfully debited in the sum of 416,390 naira 4 kobo for repayment of loan he obtained. According to the claimant, the loan had been insured by the defendant under the category of job loss. However, the defendant wrote a mail demanding for the liquidation of his loan, and that in his reply, he intimated the defendant of the existence of the policy with the first insurance and requested that the said insurers be contacted for liquidation of the loan. Copies of correspondences of one Stella Maris O. Uzome, acting on behalf of the defendant, and the claimant's statement of account from 1st of June 2021 to 23rd of June 2021 were respectfully tendered in evidence as Exhibit C7 and C6. While answering questions under cross-examination by the learned defendant counsel, the claimant admitted that as a member of staff of the defendant, he enjoyed loan facilities, that he obtained loans on September 2019 and October 2020, and that his account was debited for repayment of the loan he obtained in 2019. The claimant further admitted that a loan in the sum of 4,653,692 naira 87 kobo has not been repaid, and that the loan has remained outstanding because it has been indemnified by First Bank of Nigeria insurance policy by reason of his job loss. The documents relating to the loan facilities, namely application for personal loan, letter of offer of credit facility dated the 19th of June 2019, offer of personal loan dated the 20th of October 2020, credit life assurance policy and statement of account of the claimant from 1st of April 2021 to 23rd of July 2021 were respectfully tendered through the claimant as Exhibit C9, C9A, C9B, and C10. In his testimony as the sole witness of the defendant, DW1 admitted that the termination of the claimant's appointment was not due to non-performance or for any act of misconduct, but was in exercise of the defendant's right as contained in Exhibit C2 that allows either parties to terminate the appointment by giving appropriate notice or payment of salary in lieu of notice. DW1 further testified that pursuant to the terms of employment and as reflected in Exhibit C10, after cessation of his employment, the claimant was paid 1 month's salary in lieu of notice and 2 months ex gratia. DW1 also testified that since the cessation of his appointment, the claimant has not liquidated the staff auto loan and personal loan that was obtained while he was in the employment of the defendant, that he was indebted to the defendant in the sum of 5,653,692 naira 87 kobo when his appointment was terminated. And to reduce his indebtedness, the defendant applied the 2 months ex gratia payment and graciously granted a waiver on all upfronts on end annual and quarterly allowances that had been paid to him. In his further testimony, DW1 admitted that the claimant's loan was insured with FBN insurance, but as contained in the insurance policy, the benefit payable for job loss is in monthly installments and restricted to 6 months installments. DW1 testified further that after the payment of job loss benefit, the outstanding balance payable on car loan was 1,866,666 naira 55 kobo, while the payable outstanding balance on the personal loan after the payment of job loss benefits was 1,579,166 naira 67 kobo. DW1 also testified that having deducted the job loss benefits as contained in credit life assurance policy, the claimant is still liable to pay the defendant the sum of 3,455,833 naira 22 kobo, being the outstanding balance of the loans, regardless of cessation of his appointment. DW1 denied the entirety of the claimant's claim and maintained that his appointment was terminated in accordance with the terms and conditions of his employment. DW1 alleged that the claimant has failed and refused to pay the indebtedness in spite of repeated demands. In his reply to the statement of defense and defense to counterclaim, the claimant categorically denied being indebted to the defendant in the sum of 3,445,883 naira 22 kobo or any sum at all as alleged, and maintained that the loans he obtained from the defendant is to be settled by the insurance company. The claimant also denied that parties had an agreement that the loan will attract an interest of 21% per annum. By my understanding, the claimant's grievance against the defendant is that he did not commit any offense or misconduct to warrant the termination of his appointment, that court services no longer required, end of quote, is not included as one of the reasons in the employee's handbook for termination of appointment, and as such, the purported termination of his appointment by the defendant on the ground that his services are no longer required is wrongful and in violation of international best practices. His further contention against the defendant is that his account was wrongly debited the sum of 416,390 naira 4 kobo, that the outstanding loan that he obtained from the defendant has been insured on the job loss by the defendant, and that the defendant ought to have made a claim to the insurance for repayment of the said loan. The claimant also contends that he is entitled to be issued with certificate of meritorious service for the furtherance of his career, and alleged that he has suffered untold hardship for loss of job and therefore entitled to general damages for breach of contracts of employment. The particulars of the allegations by the claimant against the defendant are stated in paragraphs 10, 11, 12, 13, 14, 15, 18, 19, 20, 21, 29, 22, 29, and 31 of his witness deposition on oath. Now, parties are ad idem that the employment between the claimant and the defendant was governed by Exhibit C1, letter of offer of employment, and Exhibit C2, the defendant's employee handbook. Learned Claimant's Counsel in his submission considered that the defendant had the right to terminate the appointment by issuing the requisite notice or payment of 1 month salary in lieu of notice as contained in section 7.8.1 of Exhibit C2. Learned counsel, however, argued that the defendant cannot solely rely on this provision to the exclusion of the provision of section 16.2.2 of Exhibit C2 to terminate the claimant's appointment. Learned counsel argued further that the letter of termination of claimant's appointment did not state any reasons as provided in Exhibit C2, but rather it was stated in the letter of termination that your services are no longer required. Learned counsel submitted that having failed to state any of the reasons as enumerated in section 16.2.2 of Exhibit C2, the termination of claimant's employment was wrongful and urged the court to set aside the purported letter of termination of employment. It is the further submission of learned counsel that the common law position that employer can terminate employment of an employee without any reason has been abolished, and this honorable court has been enjoined to adopt treaties and conventions, including international best practices as it relates to labor law. Learned counsels also submitted that by international best practices, the termination of a claimant's appointment for services no longer required is not a valid reason. Learned counsel cited the provisions of sections 2546 sub 2 of the Constitution of the Federal Republic of Nigeria, 1999 as amended, section 7 sub C, National Industrial Court Act, 2006, Convention number 158 of International Labour Organization, recommendation 166 of the International Law, and Article 4 of the Termination of Employment Convention of International Labour Organization, 1982. And the cases of Aloysius versus Diamond Bank PLC, Ademolekun, Benga Cosmos, and others versus Union Home Savings and Loans PLC, Nwosu versus Guinness PLC, Aderonke versus Skybank PLC, Elder Mr. Olatubosun Oluwasogo Fadirepo versus Access Bank, citations all supplied were cited to buttress his submissions. The defense advanced by the defendant is that by the terms of employment as contained in Exhibit C2, it had no obligation to state any reason for terminating the claimant's appointment. With reference to section 7.8 of Exhibit C2, learned defendant counsel argued that after confirmation of employment and for any employee below the acting general manager grade, either parties may terminate the employment by either giving 1 month's notice or payment of 1 month's basic salary in lieu of the required notice. Learned counsel submitted that as at the date Exhibit C5, the letter of termination of appointment was issued, the defendant had exercised its right by paying the claimant, who was a deputy manager, the sum of 221,420 naira, 33 kobo as 1 month's basic salary in lieu of notice, as reflected in the claimant's statement of account in Exhibit C11. Citing the cases of Adamu Mohammed Bedu and 10 others versus John I. Itie, liquidator, and 3 others, the case of Julius Badger, Nigeria PLC versus Godfrey Nwaogu, the case of Dr. O. Ajolore versus Kwara State College of Technology, the case of ex-Captain Charles Ekwagu versus Nigeria Army and another, the case of Jerawa Oil Means Limited and Abdulkadir Manzo Babura, citation all supplied, learned counsel submitted that where the claimant, as in the instant case, accepts salary or payment after his employment has been brought to an end, he cannot complain later that his contract of employment was not properly determined, as the receipt of payment by the employee renders the termination mutual. Learned counsel urged the court to hold that as contained in agreement, that is Exhibit C2, that was freely executed by parties, the claimant's employment was properly and validly terminated by the payment and the receipt of 1 month's salary in lieu of notice. At this juncture, I should remark that the cases of Adeniyi versus Governing Council of Yaba College of Technology and Military Administrator of Benue State versus O.P. Ulegede and another citation supplied that were cited by Learned Claimants Council to debunk the position of law that the payment of 1 month's salary in lieu of notice renders the termination mutual are distinguishable for the present case. The cases of Adeniyi versus Governing Council of Yaba College of Technology, Supra, and Military Administrator of Benue State versus OPL Ulegede and another Supra are employments governed by statute, in which case the employers are required to determine the employment by strict compliance with the provisions of the statute. Now, it is not in doubt that this is a case of master and servant and not a contract of service with statutory flavor. In the circumstances, it is settled and as correctly submitted by respective learned counsel for contending parties that the contract of service is the bedrock where the issue of wrongful termination of employment calls for determination. See again the case of Amodu versus Amode, Nwachukwu versus Nwuze, citation supplied. The contract of service is the bedrock which an aggrieved employee must found his case, and it succeeds or fails upon the terms thereof. Therefore, in a written or documented contracts of service, the court should not and will not look outside the terms stipulated or agreed therein in deciding the rights and obligations of the parties. See the case of Western Nigeria Development Corporation versus Abimbola. In the present case, parties agree that the terms and conditions of the contract of service between them provide for notice to be given before termination. The claimant tendered Exhibit C1, the letter of offer, and Exhibit C2, the contracts of employment, as the terms guiding or regulating employment. Paragraph 7.8.1 of Exhibit C2 states as follows, I quote, after confirmation, employment may be terminated by either party giving the other 1 month's notice or payment of 1 month's basic salary in lieu of the required notice period for employee below AGM grade. For employees on AGM grade and above, employment may be terminated by either party giving the other 3 months notice or payment of 3 months basic salary in lieu of the required notice. End of quote. The above is the contract which the claimants entered into with the defendant. On the cross-examination by learned defendants counsel, the claimants testified as follows, I quote, from inception of my employment, I was given Exhibit C2. After confirmation of appointments, the employment may be terminated by either party by giving 1 month's notice or 1 month's salary in lieu of notice. My rank before the termination was below AGM. I was a deputy manager. Pursuant to the provision, I received 1 month's salary in lieu of notice. I did not receive 2 months' salary as ex gratia. End of quote. The question arises, having collected his entitlements as provided in his contracts of employment, can the claimants reasonably complain or be heard to say that his termination was wrongful? I suppose not. Parties are bound by the terms and conditions of the agreement. The law is trite that where parties to a contract mutually agree that the condition for determination is the giving of notice or payment of equivalent salary in lieu of notice. Once the employer gives the notice or pays the equivalent salary in lieu of notice, he has discharged his obligation under the contract. A willing and able employee, that is a servant, cannot be imposed on an unwilling employer, that is a master, and vice versa, where the employee decides to quit and discharges his obligation by giving the due notice or paying the equivalent salary in lieu of notice. A willing and mighty employer cannot compel the unwilling employee to remain his in its employment. So the cases of Olanio and others versus University of Lagos, Moron Fola versus Kwara State College of Technology, Dr. O. Ajolori versus Kwara State College of Technology, citation supplied. Having accepted 1 month's salary in lieu of notice, it seems to me the claimant has put to rest any contract, real or imagined, which he has or thought he had with the defendant. The contract was validly and mutually determined in accordance with the terms and conditions prescribed in Exhibit C2, the contract of employment, and I so hold. Therefore, the claimant is not entitled to his claims for special damages and general damages, since those claims are hinged on his claim for wrongful termination of his employment, and I so further hold. The claimant's further grievance against the defendants is for the refund of the sum of 416,390 naira for kobo allegedly debited from his accounts by the defendant for the repayment of the loan he obtained before his appointment was terminated. According to the claimant, in the event of his job loss, the said loan is under cover by the defendant's insurers, and same ought to have been liquidated by the defendant's insurers. The defense put forward by the defendant is that the deduction of the said sum of money was made to liquidate part of the loan obtained by the claimant. Learned Claimant's counsel argued that Exhibit C10, the insurance policy, is not binding on the claimant, not being signatory to the policy, as same was between the defendant and First Insurance. Learned counsel further submitted that Exhibit C10 is not the policy in respect of the outstanding loan debited by the defendant, and further argued that Exhibit C12, C12A, C12B are inadmissible and ought to be expunged by the court. With due respect to Learned Claimant's counsel, this argument is not only misconceived, but it's also aimed at misleading the court. The claimant in paragraph 4D of the claimant's reply and defense to counsel gave notice to the defendant to produce the policy signed by the claimant, as borne by the records of the proceedings of the 17th of July 2023. Exhibit C12, C12A, C12B were tendered from the bar by Learned Defendant's counsel without objection. In Chief Bruno Etim and others, and Chief Odo Oko Ekpe and another, 1983 Supreme Court 12 at page 36 to 38, Ania Golu JSC held as follows, I quote, "It is a cardinal rule of evidence and of practice in civil as well as in criminal cases that an objection to the admissibility of a document sought by a party to be put in evidence is taken when the document is offered in evidence, barring some exceptions whereby law certain documents are rendered inadmissible. The rule still remains inviolate that where objection has not been raised by the opposing party to the reception in evidence of a document, the document will be admitted in evidence and the opposing party cannot afterwards be heard to complain about its admission." End of quote. See also the case of Naba versus Dantata, 2022, Law Pavilion Electronic Law Reports at 58155. It is equally borne by the records that the claimant categorically admitted that he obtained the said loan from the defendant, and his further admission is that the loan has not been repaid because it was insured on the cover for job loss by the defendant. The claimant's contention that the said exhibits are inadmissible is strange. Interestingly, it is the same insurance policy that the claimant is relying on for his claim for liquidation of a payment of his loan under job loss. In this regard, the claimant is unstable. In the Holy Scriptures, there is punishment for instability. A person who is unstable will not get what he asks for and will not excel. The law also does not allow a person to appropriate and reprobate at the same time, which amounts to blowing hot and cold in the same breath. One cannot eat his cake and have it back. The contention on the inadmissibility of the said exhibit, to which objection was not raised, is not only an afterthought, but clearly mischievous and entirely without substance, and as so hold. The claimant has not proved by credible evidence the claim for the refund of the sum of 416,390.04, and I so further hold. On the basis of the foregoing analysis, therefore, I must and I hereby resolve issue 1 for determination, issues 1 and 2 for determination in the suit against the claimant. It is therefore the conclusion of the court that the claimant has failed to lead credible evidence in support of the reliefs claimed against the defendant in this action. Accordingly, it is the judgment of this court that the claimant's claim is unmeritorious. It shall be, and it is hereby accordingly dismissed. The defendant counterclaims for the sum of 3,445,883 naira 22 kobo, being money payable by the claimant to the defendant as outstanding balance of car and personal loans against salary advanced to the claimant, and for interest agreed to be paid at the close of the banking business on the 31st of October 2022. It is settled that a counterclaim is for all intents and purposes a separate, independent, and distinct action, and the counterclaimant, like all counterclaiming main actions, must prove his counterclaim with credible and convincing evidence to obtain judgment. Exhibit C9, C9A, and C9B, C10, and C11 were attended to prove the counterclaim with reference to paragraphs 10, D, E, F, G, and 11 of the statement of defense. The defendant admitted that the loans obtained by the claimants was insured, but averred that under the insurance cover for job loss, the benefits payable to the claimant is monthly installments and restricted to a maximum of 6 months installment. The defendant further averred that the sum being counterclaimed is the outstanding balance of the loans after deducting the job loss benefit due to the claimant. Exhibits C11, C12, C12A, and C12B were tendered in evidence to further buttress the case of the defendant's counterclaim. It is equally a settled position of law with statutory backing and a legion of decided authorities that what is admitted needs no further proof. By Section 123 of the Evidence Act 2011, no facts needs to be proved in any civil proceeding which the parties to the proceeding or their agents agreed to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, by this provision generally in civil proceedings, unless the court deems it fit as provided for in the proviso to call for further evidence, what is admitted requires no further proof other than by such admission. There are too many cases on this principle. See Akinlagun versus Oshoboja and Ojuku versus Nwoduwe and others, citations supplied. Clear and unequivocal evidence on record as admitted by the claimant is that he applied and obtained car and personal loans while he was in the employment of the defendant, that as the time his appointment was terminated, he had not made payment for the loan he obtained from the defendant, and that approval was granted for waiver of the unearned portion of the upfront and quarterly allowances which had been included in the computation of his indebtedness. See Exhibit C7A, C9, C9A, and C9B. Having undertaken an extensive evaluation of the evidence adduced and support and against both the main suit and the counterclaim together in the foregoing, I hereby permit myself to adopt the court's findings and conclusion in the foregoing, in holding that based on the documentary evidence and the copious admissions of the claimant, the defendant is entitled to the repayment of the outstanding balance of the said loans, the counterclaim having been found to be meritorious, and I so hold. On the claim for interest at the commercial rate of 21% per annum from 1st of November 2022 till payment or judgment or thereafter, I should state that there is a clear court distinction between interest awarded on judgment debt and prejudgment interest. A judgment awarded on judgment debt is purely statutory and can only be awarded if there's a provision to that effect in the law or rules of court. See the cases of Balliet Nigeria Limited versus Kachala, Equinefe versus Wayne West Africa Limited, Silverbird Galleria Limited versus Nivoid Construction Nigeria Limited, citation also applied. On the other hand, regarding prejudgment interest, I find the decision of the Supreme Court in A.G. Ferrero and Co. Limited versus Enkel Chemicals Nigeria Limited, which is in line with its previous position on the issue, most instructive. In that case, my Lord Onoge JSC said, I quote, the principle relevant to the issue under construction has been laid down in a number of cases, thereby becoming settled law that a claim for prejudgment interest may be made by a plaintiff is a right where it is either expressly provided for in or is contemplated by the agreement between the parties or under a mercantile customs or under a principle of equity, such as breach of fiduciary relationship. It follows that before a party can claim prejudgment interest, he has to plead not only his entitlement to the interest, but the basis of the entitlement, either by statute or contract agreement between the parties or mercantile customs or principle of equity, such as breach of fiduciary duty. It is not for the court to speculate on conjuncture or assume the facts relevant to the claim. The consent claim in issue in the instant case does not seek interest on judgment sum, on judgment debt, but interest predating the judgment. But there were neither pleadings nor evidence on specific details of any agreement of the parties on the prejudgment interest. It has not been pleaded or shown to be a mercantile custom. I note from Exhibit C12A and C12B that interest, as agreed by parties, had been applied on the loans advanced to the claimants. Having not proved the specific details on any agreement or the prejudgment interest, the counterclaim for interest at commercial rate fails and are so hold. In the final analysis, the defendant's counterclaim succeeds in part. For the avoidance of doubts and abundance of clarity, judgment is hereby entered in respect to the counterclaim on the following terms. 1. The counterclaimant, defendant to the counterclaim, shall pay the counterclaimant the sum of 3,445,833 naira 22 kobo, being outstanding debt on balance of car and personal loans on the salary advance to the claimant. It is hereby further ordered that the claimant, defendant, counterclaimant shall pay the sum set out in 1 above within 30 days to the defendant's counterclaimant. Parties shall bear their respective costs. This is the judgment of the court.
As the court pleases, my lord.
The court pleases.
As the court pleases.
Thank you.
Thank you, my lord, for the well-considered and erudite judgments.
Thank
We're
you,
most
Lord.
grateful.
The judgments will be transmitted somehow before the end of this week, so you may apply for it for whatever purpose.
As the court pleases.
Thank you. The court will rise
court
now.
Thank you, my lord. I'm not hearing again.
They muted you.
They muted you.
She muted herself.
This judgment,
Hello? Hello? Babana? Babana?
Judgment of the claimants, you said what?
Claimants claims dismissed in total.